Yes, Mr. Rossiter.
Thank you, my Lord. I was going to Tabillon next, which is at EF, page 896, and is, of course, the foundation of the line of United States cases on diplomatic immunity, which are against me. And you'll see at page 898, the second column, however, halfway down, at least so far as ordinary meaning, or literal meaning, as it's put here, is concerned, the case is, we say, not entirely unhelpful to Miss Wong's position. Looking solely at the words commercial and activity, the phrase commercial activity could logically encompass the defendant's dealings with the claimant. Now, of course, the court then, in some fairly brief reasoning from the second column on page EF, page 898, over the page to 899, then draws attention to four matters which justified a departure from the literal meaning and a finding that immunity did indeed apply. The first was indications of context showing that personal profit was required. This is all in the second column on page 898, in the paragraph beginning the phrase commercial activity. The first was indications of context showing that personal profit was required. The second was what was said to be the treaty's background and negotiating history, so the travaux. The third was what was described as its subsequent interpretation, which was a reference to the executive branch of the United States' subsequent interpretation of the treaty. And the fourth was what the court said would be to ignore the relevance of the remainder of the phrase outside his official functions in Article 31. And Mr. Basfar, of course, understandably relies upon Tabillon, and Lord Sumption referred to it in his judgment. Now, Miss Wong contends that there are 5 reasons why the approach in Tabillon should not be followed, even putting to one side the fact that it was not in terms alleged to be a trafficking case, and so there wasn't explicit consideration of the harmonious interpretation international rules point that I'll come to. First, the reliance on personal profit and Article 42 of the Convention is misplaced for the reasons I've already sought to submit, and the notion of personal profit is in any event satisfied in the trafficking context. Secondly, the Court of Appeal's brief analysis of the travaux overstated the assistance they provide for reasons which I'll come to in more detail. Thirdly, the reliance on subsequent interpretation of the term commercial activity does not, we submit, go very far for the purposes of this court in circumstances where that subsequent interpretation was limited to one jurisdiction, and in this context was limited to the interpretation adopted by the executive, and in circumstances where another jurisdiction, Portugal, has, as I've already submitted, arrived at an opposite conclusion on immunity. Fourthly, and related to that, United States principles of interpretation require, as a matter of constitutional law in the United States, substantial deference to be afforded to the views of the State Department, or great weight, as it's sometimes put, to be afforded to the views of the State Department. And that is, of course, a principle which is not applicable in this jurisdiction, in respect, at least, of questions of law. And fifthly, the court was, we say, wrong to say that a broad meaning of the term commercial activity ignored the relevance of the phrase outside his official functions. Instead, if anything, we say the addition of those qualifying words lends itself to a broader interpretation of the term commercial activity rather than a narrower one, because the words outside his official functions then provide a limit preventing any loss of immunity in areas genuinely engaging state or sovereign interests. So, for example, in an indisputably commercial context, whether for the purchase of arms or aircraft, if a diplomat were involved in the negotiation of such a contract, and a commercial claim ensued, the state would have no immunity under conventional customary international law principles, but the individual diplomat would, as he would have been acting within his official functions. Treating the words outside his official functions in this way in an employment context, closer to the territory of this case, also, we say, allows the court to apply what would ultimately be a common sense, fact-specific remoteness test, just as customary international law does in the context of state immunity and employment cases, and just as the statutory schemes in Canada and the United States do too. See Benkebouche, see the Canadian Labour Code case. There may well be a requirement to afford immunity in cases which concern even a relatively junior employee, because he or she is genuinely involved in official sovereign functions, whether translating sensitive texts or otherwise, or has access to sensitive sovereign material. But there's no reason to take such a course when dealing with employees engaged in purely domestic functions, whether as cooks or cleaners or other domestic functions. And it's right to note, so far as Tabillon is concerned, that even Lord Sumption's enthusiasm for it was not unconstrained. As the court will have noted at paragraph 23 of his judgment, EF 878, he rejected Tabillon's approach to the meaning of outside his official functions for the purposes of determining residual immunity. Now, resting the matter there for the moment, on the basis of the terms used in the Convention, on the basis of the comparative law, there is an entirely adequate foundation to justify Lord Wilson's doubts about Lord Sumption's analysis. And we say, on the contrary, that when the point has to be decided, they point against that analysis. And that conclusion is, we submit, strongly reinforced when the final exercise envisaged by Article 31(3)(c) of the Treaties Convention is undertaken, and when regard is had to other relevant rules of international law applicable in the relations between the parties. Now, one preliminary point on that, which is common ground, as I understand it, between the parties, but in any event, as we say, the correct position. This is an exercise which embraces rules both in existence as at 1961, when the Diplomatic Relations Convention is drafted, and rules which are in existence now, at the time the dispute comes to be resolved. And we get that in, amongst other places, from the International Court of Justice Namibia Southwest Africa Advisory Opinion, which is at EFP page 3376. And as you see from paragraph 53 there's a passage immediately after the passage from this opinion quoted by Lord Sumption, which makes this point. So that's the general position. One example of an international court deploying Article 31(3)(c) of the VCLT to ascertain the contemporary meaning of another treaty is the European Court of Human Rights in the Rantsef decision, which is at EF 3684. And I'll come to the case in more detail, but in essence in that case, the Russian government disputed that human trafficking fell within the scope of Article 4 of the European Convention on Human Rights, on the basis that Article 4, drafted in 1951, did not expressly refer to human trafficking. And the court referred both to the VCLT, the Treaty Convention, and to the need to take into account relevant rules of international law under Article 31(3)(c). It referred to the Palermo Protocol, which of course postdates the European Convention on Human Rights, but to which Russia, along with virtually every other state, is party, and it held that Article 4 of the Human Rights Convention had to be interpreted as including human trafficking. The other preliminary aspect of this stage of the Treaty Convention analysis relating to relevant international rules is that we accept entirely that the rules relevant to the exercise must bind both the Kingdom of Saudi Arabia and the United Kingdom, namely the parties before the court on this dispute. In addition,
they can't have a different meaning depending on where the diplomat comes from, can it?
No, my lord, and the point that I'm making here is that it's to meet the point about regionalism, so far as 31.3c is concerned. There's a legitimate concern that you can't broaden the treaty through 31.3c by reference to a regional instrument which doesn't bind and isn't signed up to by one of the relevant parties.
But it's not just that it's one of the relevant parties, is it? That it's just a regional convention,
yeah.
Whereas the Diplomatic Relations Convention is as near universal as you can get.
My lord, yes. It may be that some regional instruments, and this is a point Lord Wilson makes, and I'll come back to, some regional instruments are by definition regional because that's what they say on the tin, so to speak. Yeah. European Convention of Human Rights, Arab Charter.
The number of signatories and the part of the world which is within its compass.
Exactly, but they may also be reflecting a global position. They may, for example, owe their origins to the UN Charter, and so in that sense they may still be relevant to the analysis, but only if they satisfy those conditions.
But I'm not sure then what your answer is to my Lord Legate's point about, well, can it mean something for, can it mean something different in relation to a state which has not signed up to the Palermo Protocol?
So far as treaty rules are concerned, I would say it would be more difficult for me to invoke the Palermo Protocol as an aid to interpretation if Saudi Arabia had issued reservations in relation to it or refused to sign up to it. And that is...
why is that so? Surely we're just interpreting what the Vienna Convention means, and whether the particular parties have signed up to some other treaty or not can't be the test.
I think the way it could be put would be to say that the ultimate exercise that is being engaged in interpretation of the Vienna Convention of Diplomatic Relations is to search for the intention of the parties. And if you had a fact pattern which showed unequivocally an intention in a different direction from one of the states before a court, it might be more difficult to make that case. But
I don't understand. I don't follow that. I'm sorry. Yeah. If they've signed up to the Diplomatic Relations Convention and it has a particular meaning, there you are, it has the meaning.
Yes, and the question is, what are the relevant rules, well, the wording, to go back to Article 31.3c of the Treaties Convention, which is...
Yeah, you're relying
614,
at this point on Article 31.3c of the Treaties Convention that refers to any relevant rules of international law applicable in the relations between the parties.
And the question is, what does applicable in the relation between the parties mean for these purposes?
Yes.
Now, on one view, it could mean you've got to be able to appoint to an instrument which has an exact identity of signatories with the Vienna Convention on Diplomatic Relations. And unless you can do that, you can't invoke any rule of international law. And we say the correct approach instead is to look for relevant rules applicable in the relations between the parties to the dispute about interpretation.
Does it mean the parties to... Does it mean the parties to the dispute or the parties to the convention?
Well, that's what we're wondering.
Well, that's exactly the question, my lord.
Well, we're looking at a general rule of interpretation.
We're looking at a general rule of interpretation.
It was about parties to some particular dispute, wouldn't it?
Perhaps I can put it no better than to at least refer to the International Law Commission's report on the question of fragmentation, which tends to support the approach that I've submitted, which the court finds at EF page 5052, if my note is correct. And the material paragraphs, I think, are 413 and 414 of the fragmentation report.
413.
413 is talking about the concept of systemic integration, which I referred to earlier, and then sets out 31.3c. 414 talks about reference to or the rationale for the principle being understandable. Just looking for the.
Well, I thought you were referring us to 471A.
Yeah, I'm sorry. Yes,
5052. I thought you said.
Yes, I'm sorry.
That says it precludes reference to treaties which have very wide acceptance in the international community, including by the disputing states, but which are nevertheless not universally ratified and which are not accepted as stating customary international law.
Yes, it's 472.
Well, that's one view, but you're pointing us to 472, are you? A better solution. That's your submission.
Yeah.
It's 472.
Yeah.
It's 472, first sentence. 413 and 414 are perhaps useful as looking at the rationale. And probably I've wasted some of my valuable time on this because we say it's ultimately academic here, because as Lord Wilson points out at paragraph 60 of his judgment, in effect, every state in the world is a signatory to the Palermo Protocol. The point I was really making was that my position is stronger because, save in one respect, every treaty I point to and every principle of customary international law I point to, I should say, save in two respects, are treaties and principles which bind the Kingdom of Saudi Arabia. Now, in addition to treaties which bind both states and customary international law on state immunity, it's also important to bear in mind that Article 31.3c is capable of embracing what are called general principles of law recognised by civilised nations, and the reference for that is our printed case at 70, citing Demir in Turkey in the European Court of Human Rights. That would include, for example, the general principle as to the importance of the obligation to combat human trafficking, the obligation to protect its victims, recognised by, amongst other instruments, Article 10 of the Arab Charter and Article 4 of the European Convention. And against that background, we rely upon the following core principles of international law for the purposes of this 31.3c exercise. Firstly, the principles of state immunity and the position as a matter of customary international law, which we've seen illustrated in some of the United States case law and by the court's decision in Benkabush. There is no requirement in customary international law to afford immunity to states in relation to employment of domestic staff. Secondly, as illustrated by Park and Shin, the position under the Consular Relations Convention shows there is no requirement to afford immunity for consular officials in relation to the employment of domestic staff. And from a state perspective, that employment too is treated as constituting commercial activity. Thirdly, and then critically for the purposes of the outcome in this appeal, we say, the comprehensive network of rules relating specifically to what Lord Sumption called the trafficking dimension, and which Lord Wilson saw as embracing a raft of international and indeed regional instruments, all of them emphasising, as he put it, the international community's determination to combat human trafficking, and all of them underscoring the importance of trafficking victims having a right to a remedy. Now, so far as the first two of those sets of rules are concerned, I've got nothing to add really to what I've already said, save to emphasise again the point that I concluded on shortly before the short adjournment, that by the time of the conclusion of the Vienna Convention in 1961, the movement towards restrictive immunity was well underway, and so inclusion of an exception to immunity based on commercial activity would reasonably be expected, we say, to be in harmony with that movement rather than in discord with it. So far as the trafficking dimension is concerned, I'd like to go briefly to each of the material instruments and also show the Court what the European Court of Human Rights has said in that context. Before doing so, though, I'd like to go to the case of Al-Daloumi in the European Court of Human Rights for the assistance we say it provides more broadly on the issue of harmonious interpretation. That is at EF 3412, and it's referred to for reference in our printed case in the footnote 25 at EF 351. And we rely upon it in support of the proposition, consistent with 31(3)(c), that there is an obligation to construe ambiguous international measures in a manner which minimises conflict and which is most in harmony with rights protected in the Human Rights Convention. Now, that case concerned the confiscation of assets pursuant to a UN Security Council resolution. And the complaint of the applicant in that case was that the grounds of challenge to such confiscation were limited to questions of identity and ownership and permitted no challenge at all to the basis of listing in terms of the act allegedly engaged in by the relevant person. And the point of principle is addressed at EF page 3478, paragraph 138, where the court says this: states are assumed not to derogate from their previous obligations. Where a number of apparently contradictory instruments are simultaneously applicable, international case law and academic opinion endeavour to construe them in such a way as to coordinate their effects and avoid any opposition between them. Two diverging commitments must therefore be harmonised as far as possible, so that they produce effects that are fully in accordance with existing law. And the obligation of harmonious interpretation in cases of ambiguity is then set out at paragraph 140. And the court then applied those principles at 146 and held that unless a Security Council resolution expressly excluded the potential for judicial review at the domestic level to safeguard against arbitrariness, then states would be obliged to provide such a review. Now, so far as the trafficking context itself is concerned, the full set of interlocking treaties that we rely upon and which are addressed in the various printed cases before the court, which we say should be construed in a harmonious fashion, are set out in the table that I hope reached the court on Monday when we sent it to the registry. And I'd like just to say very little about each of those instruments, if I may. The Slavery Convention is the first in time. That is at EF 1560. And you have there at Article 1.1 the definition of slavery as the status or condition of a person over whom any or all powers attaching to the right of ownership are exercised. So the same root concept of treating people as commodities referred to by the European Court and Lord Wilson is evident from the outset. And at 1.2, you have then provision that the slave trade includes all acts involved in the capture, acquisition or disposal of a person with intent to reduce him to slavery, and in general every act of trade or transport in slaves. Now, on that basis, even at 1926, international law is recognising, we say, that taking someone into your control with the intent to reduce them to slavery is an act within the slave trade. And Article 2 then provides that the high contracting parties undertake to prevent and suppress that trade. The Forced Labour Convention is next, chronologically. That's SUP EF 683. And here, by Article 1.1, each member of the International Labour Organization undertakes to suppress the use of forced labour. And by Article 2.1, forced labour is defined to mean all work or service which is exacted from any person under the menace of penalty and for which the said person has not offered himself voluntarily. Article 25 provides that the illegal extraction of forced labour shall be punishable as a penal offence, and it shall be an obligation of on any member state ratifying the Convention to ensure that the penalties imposed by law are really adequate and strictly enforced. So again, while the focus is on criminal proceedings, it's clearly contemplated that at least some form of jurisdiction is to be asserted. The European Convention then comes next in our chronological run, again, of course, preceding the drafting of the Diplomatic Relations Convention. And Article 4 is, of course, the material provision here with its prohibition on slavery, servitude and forced or compulsory labour. And Article 4, we now know, encompasses human trafficking. This was one of the points the European Court explained in Ransef and Cyprus, which I'd like to go to by way of digression at this point, if I may, to EF 3684. And the Ransef case, referred to, of course, by Lord Wilson, is important, we say, for three reasons. First of all...
Sorry, what was that number?
EF 3684, my lady. First, as I've already indicated, it's a direct example of Article 31(3)(c) of the Treaty Convention supporting the interpretation of a treaty having regard to subsequent developments in international law concerning human trafficking. Secondly, it shows the conceptual lineage from traditional slavery to modern slavery. And thirdly, and separately, it identifies the positive obligations to victims of trafficking that emerge from international human rights law. Now, the first 2 points are addressed at paragraphs 272 to 282, starting at EF 3733. As I've already mentioned, the context for this passage of the judgment is the contention of the Russian Federation that human trafficking was not within the scope of Article 4, because not expressly mentioned in it. At paragraph 273, the Court refers to the need to interpret the Human Rights Convention in accordance with the principles of interpretation under the Treaties Convention. This is 3743, I think, sorry. The Court then refers to, at 274, the Court then cites Article 31(3)(c) and a sequence of its previous cases, Golder amongst others, applying that provision so as to interpret the Convention in light of relevant rules of international law and in harmony with them. 277, the absence of an express reference to trafficking in the European Convention is commented on and explained with reference to the fact that it was modelled on the 1948 UN Declaration with its prohibition on slavery and the slave trade in all its forms. 278, the Council of Europe's Anti-Trafficking Convention and the Palermo Protocol are both referred to as demonstrating the increasing prevalence of trafficking and the need for measures to combat it. 280, the Court cited the conclusions of the International Criminal Tribunal for Yugoslavia and its consideration of the evolution of the traditional concept of slavery to embrace a range of situations of control and confinement. And 281, we have the passage from the Court cited by Lord Wilson and the conclusion at 282 that trafficking itself, within the meaning of the Anti-Trafficking Convention and the Palermo Protocol, fell within Article 4. 286 to 287, we then have the Court explaining why Article 4 carries with it positive obligations and may require a state to take operational measures to protect victims. And in determining the scope of those positive obligations, the Court then draws particular attention to both the Anti-Trafficking Convention and the Palermo Protocol. And then more recently than Ransef, in a judgment that was handed down shortly before the Supreme Court hearing in Reyes, we had a further decision from the European Court, Chowdhury and others against Greece, expressly identifying Article 15(3) of the Trafficking Convention, the provision which requires provision of a remedy against the perpetrator of trafficking, as falling within the positive obligations of Article 4 of the Human Rights Convention. And that's the point we make at 76.3 of our printed case. Now, going back to the table then, the next in time is the Diplomatic Relations Convention, then the Consular Relations Convention 2 years later, the Palermo Protocol from 2000 is next, and the material provisions are, of course, the definition of trafficking itself, which I've already gone to, and the obligation relating to compensation at Article 6.6, which is at EF 636. Now, it is true, and it's a fair point that can be made, that Article 6.6 does not expressly refer to provision for compensation from perpetrators. But its general words do not exclude that either. And if the exercise that the court is engaged in here is one of promotion of harmony and avoidance of fragmentation, we say it is a provision which strongly supports Ms. Wong's position. Now, the Arab Charter comes next in 2004, chronologically, and coming in 2004, perhaps it's unsurprising that it's actually more up-to-date than the European Convention on Human Rights. And Article 10 of the Arab Charter, at EF page 1566, contains an express prohibition not just on slavery, but also on trafficking. And Article 12 guarantees the right to seek a remedy before the courts. And we then have the Council of Europe's Convention on Action Against Trafficking from 2005, with its important provision at Article 15.3 that I've already referred to. And then finally, bringing the matter right up to date, at least into the second decade of this century, we have the Protocol to the International Labour Organization's Forced Labour Convention at EF page 1584, signed up to by the Kingdom of Saudi Arabia this year. Now that emphasises, to go back to a point that was raised with me by my Lady Rose earlier today, that emphasises in the preamble at 1584, in I think the third recital, the interrelationship between forced labour and trafficking. And it emphasises at Articles 1, 3 and 4 the obligation on states to provide victims of forced labour with protection and effective remedies and sanction for perpetrators. Seventh recital. Sorry, it's the seventh recital. So that is the relevant network that Lord Wilson had in mind and that we say has to be considered when undertaking the Treaty Convention 31.3c exercise. And we make 7 points in respect of that network of treaties, again, all pointing in favour of the interpretation we contend for. Firstly, as at 1961, and having regard to the 1926 and 1930 conventions, those involved in drafting the Diplomatic Relations Convention must all have been taken to share a revulsion for the slave trade, and to consider that any participation in the slave trade would be entirely inconsistent with the status and ordinary functions of a diplomat and the dignity of the mission. During the hearing in Reyes, Lord Wilson posed the question why those drafting the Diplomatic Relations Convention might have thought it would interfere with the functions of missions to treat as an exception to immunity diplomats who treated their servants as slaves. And we say, of course, they could not have done. Secondly, as at 1961, and having regard to the European Convention on Human Rights, those individual delegates and drafters would also all have recognised that all state parties to that convention and other regional human rights conventions would owe obligations in respect of fundamental rights to those within their jurisdiction. And those obligations would, on entirely conventional bases, include access to court to protect fundamental rights, save where expressly required to refuse such access by international law. And to anticipate the regional point again, no delegate would have readily seen the European Convention on Human Rights to be an outlier on issues as fundamental as Article 4 of the Convention. Thirdly, by 1961, as I've already submitted, all concerned would have been aware of the move away from absolute state immunity to restrictive immunity, and of the key distinction between sovereign acts and commercial or other private law acts in that regard. The court wants a reference to that emerging trend and the dating of it. It's in Lord Sumption in Benkebush, at paragraph 51 onwards, EF 2007 onwards. Fourthly, since 2000, almost all members of the international community, including, of course, the United Kingdom and Saudi Arabia, have recognised the evil of human trafficking and have, as Lord Wilson put it, expressed their shared desire to combat it. Fifthly, as part of their treaty obligations in that regard, both states have agreed that each party to the Palermo Protocol, essentially every member of the international community, is required to ensure that their domestic legal systems contain measures that offer victims of trafficking the possibility of obtaining compensation if the victims of such conduct. And the same is true of the 2014 Forced Labour Convention Protocol. Sixthly, and critically, again, by virtue of the Palermo Protocol, all relevant members of the international community have agreed a common definition of trafficking, and that under that definition, trafficking is carried on or engaged in by everyone in the chain referred to in that definition. And seventhly and finally, Article 15 of the Council of Europe's Anti-Trafficking Convention has made it clear that there is an obligation binding on the United Kingdom to provide for victims to obtain compensation from the perpetrators of trafficking. And the European Court of Human Rights has in turn made it clear that in considering the nature and extent of positive obligations under Article 4 of the Human Rights Convention, regard has to be had to that provision. Now, there was a difference of view, of course, between Lord Sumption and Lord Wilson as to the impact of this international framework. But going back to Article 31(3)(c) of the VCLT and adopting the words of Lord Wilson at paragraph 60, relevant rules of international law applicable in the relations between the parties, at the very least, underscore the equal level of determination of all states to stamp out trafficking. And we say, of course, that the point goes further. It would promote harmony and integration and be entirely consistent with the grain of all of these rules and the position in customary international law relating to state immunity for the term commercial activity to be interpreted in the manner suggested by Ms. Wong, and for everyone alleged to be involved as a perpetrator of trafficking within the international definition to be treated as having carried it on or exercised it. Now, the first objection to this reliance on Article 31(3)(c) of the Treaty Convention, as articulated by Lord Sumption at paragraph 43 of his judgment at EF 886, and embraced understandably by Mr. Basfar, is that the term commercial activity cannot be treated, as Lord Sumption put it, as ambulatory, and must be treated as fixed in time as at 1961, when there had not been the relevant developments I've referred to in relation to the international rejection of trafficking. And there are three answers, we say, to that objection. First of all, as we have explained in paragraphs 45(1) to 45(3) of our printed case at 337 to 338, there is no justification for treating a term such as commercial as fixed in time. The International Court of Justice has, on the contrary, held in terms that a very similar term, commerce, should be treated as generic and having an evolving meaning capable of reflecting subsequent developments, particularly where it forms part of a treaty of indefinite duration. And those are the two key criteria that the Court of Justice identifies. Is it a generic term? Is the treaty intended to last essentially for a long time indefinitely? If it is, then evolutionary interpretation is legitimate. We say precisely the same should apply to the very similar term commercial activity, used in 1961, but having regard to the fact that the Convention itself doesn't define it, it's generic certainly in that sense, and having regard to the fact that the Vienna Convention on Diplomatic Relations would certainly have been seen to be of unlimited duration. Secondly, contrary to Lord Sumption's view, at least one passage in the Travaux does expressly contemplate that the approach being taken in drafting the Diplomatic Relations Convention was one which allowed an evolutionary approach, both by virtue of the failure to provide a comprehensive or indeed any definition of commercial activity, and by virtue of an express, unchallenged statement to the effect that there was a trend underway showing immunity to be eroded even in the context of bare employment situations. And thirdly, and we say dispositively, there is in any event every reason to believe that as at 1961, all those in drafting the VCDR would have considered engagement in the slave trade to be engagement in a commercial activity for which there should be no immunity. And there is no reason, we say, to believe that they would have rejected the notion that engagement in modern slavery decades later should be treated any differently. Now, I know Lord Stevens is very familiar with it from his observations earlier, but I'd like to go very briefly on the first of those answers to the Costa Rica and Nicaragua case, which is at EF page 1333. And the case concerned navigational and related rights over the San Juan River and Costa Rica's complaint that Nicaragua was in breach of an 1858 treaty. And the central dispute concerned the meaning and the effects of the words libre navegación con objetos de comercio, in respect of which, and the reason I've said the Spanish, is there was a disagreement both as to translation and as to interpretation. And the key passages for present purposes start at paragraph 57, page 1360, where the disagreement of the parties as to the words commerce and Nicaragua's case as to the meaning it had to bear being limited to 1858, the date of the treaty is set out. And at 63, EF 1361 and following, the court specifically rejected that argument. At 64, it rejected the idea that where a term's meaning was no longer the same as it was at the date of a conclusion of a treaty, or where there'd been a material development in international law, no account could be taken of that change. And it pointed out instead that in certain circumstances, parties might be presumed to give a meaning or content capable of evolution. At 65, it gave an example of such a presumption arising when a generic term was used in a treaty intended to be of a general kind of continuing duration. And it merits emphasis perhaps here that the court was treating the term as generic. It wasn't requiring the term to be expressing a general value, as Lord Sumption appears to have contemplated at paragraph 43. Certainly generic values can evolve, see the living instruments of all constitutions, but that is not how the concept of evolution is limited here. And then at 67, the Court of Justice treats the term commerce in the 1858 treaty as meeting both those criteria, so falling to be treated as capable of evolution. And we say exactly the same applies here. So the ICJ's approach strongly supports Miss Wong's contention that what Lord Sumption called an ambulatory approach may indeed be applied to commercial activity. It is a generic term, and its interpretation should be fully informed, we say, by the network of international rules relating to trafficking and the evidence as to its commercial nature available in 2021, once it is acknowledged, and this much at least must be common ground, that the Diplomatic Relations Convention was intended to be of unlimited duration.
What they decided there was that although tourism, passenger tourism on the river had not actually existed at the time the treaty was concluded, it did now exist and it did amount to commerce. But that's something different from what you're arguing for, which is that activity which certainly did exist, as you've shown, and was condemned in 1961, is now included in the term, even if it wasn't then. Well, I'm not quite sure why you rely on this ambulatory meaning. It's a different...
I appreciate the facts are different, my lady, and the analysis is different as a result, but the key reasoning in the ICJ's decision is that in deciding whether a treaty term has to be given an up-to-date modern meaning, you ask yourself two questions. One, was the term generic in nature when drafted, or was it inevitably precise and defined and fixed, like a line going down the middle of a river, which we'll come to in a moment? And two, is the treaty being interpreted one intended to have unlimited duration? And if the answer to both of those questions is yes, then the gateway to up-to-date interpretation is open in a way that Lord Sumption was not prepared to contemplate. And he was saying instead that commercial activity was not an ambulatory term and had to be given the meaning given to it in 1961.
But suppose the diplomat's husband sets himself up as a freelance coder for a computer gaming company and somebody wants to sue him for failing to perform the contract. I don't think that Mr. Basfar would argue that, well, that can't be covered by the immunity because there was no such thing as computer gaming or coding in the 1960s.
No, you're right, my lady, nor would Lord Sumption, I'm sure.
No, quite.
The
so
critical
it's ambulatory in that sense, and that things that are done now, which weren't dreamt of in the 1960s, would count as commercial activity. But that's not quite what we're talking about.
No,
here.
My lady's right, but what's critical for our purposes, we say, in terms of developments, since my primary case, as my lady's, I think, just put it to me, is that as at 1961, in fact, all the drafters of the convention would have said yes, of course, if the question had been asked, do you consider involvement in the slave trade to be involvement in commercial activity? We would say. So that's the end of it, in fact, and dispenses with the need for this debate. But on top of that, we're entitled to rely, we say, upon the relevant rules of international law, most critically, the settled universal definition of what trafficking involves and who is involved in it. And that's where the Palermo Protocol and all the sister treaties relating to it.
Isn't it a point about taking account of subsequent international law, if you like? I mean, the makers of the treaty must surely envisage that insofar as international law may evolve, this treaty will need to be given a harmonious interpretation over time.
My lord, yes. And so in the end
it may... You're not precluded in harmonious interpretation in looking at taking account of subsequent instruments.
My lord, no, and I agree. It may in the end boil down to really only a point that's needed if there's some suggested distinction between slavery, as at 1961, and trafficking, as at 2021. And if there's a suggested distinction which would prevent the feeding in of trafficking into commercial activity, then that's where the international law development comes in to show that they're the same thing, and the answer's the same as it would have been then.
Subsequent development of international law is in relation to the definition, in essence. I suppose your primary argument is that it was commercial activity back in 1961, trafficking.
Yes.
It wouldn't necessarily have had the evidence to support it insofar as you haven't got the evidence of the commercial benefits written quite so large, but it's the same activity.
It's essentially the same activity, my lord, yes. What we have got, and one of the questions Lord Sumption put to me during the course of Reyes was, would I be involved in commercial activity if I bought a slave? To which the answer I gave was, yes, you would. And that, we say, is clear from the definition from 1926 onwards, in fact, that I've already shown the court. but the argument is completely put beyond doubt when we're talking about trafficking in 2021, and we see that very clear, exhaustive definition provided, showing that it embraces everything and everyone in the chain.
Well,
purchasing a slave is owning a slave is an ongoing activity that is humiliating a person over a period of time.
And yielding us commercial benefit.
It's not like going to a shop and buying a bar of chocolate.
It's not, my lord, no.
But what do you say about, just also on the Costa Rica case, just the last paragraph of paragraph 73, on 1365, where the court says the passengers on the tourist boat are not themselves exercising a commercial activity. It's the carrier who's exercising the commercial activity. Isn't that the distinction that Lord Sumption was also drawing?
Well, yes, my lady, and that's where I sought to emphasise earlier that any notion of end user or consumer of goods it's just inapplicable and unhelpful when one's looking at this particular context of trafficking and the breadth of the definition, because everyone in the chain is extracting value, or as Lord Wilson put it, it's actually the person at the end of the chain who's driving the whole process. So it's a very, with respect, inapt analogy, we would say. No criticism of the ICJ in this case. They were right to say what they did in that case, but it's inapt as an analogy to read across to this context. Now, that leaves the position, we say, that all of the material provisions in the treaty, all of the material comparative law, all of the relevant applicable rules of international law point in the same direction in favour of the interpretation Lord Wilson, Baroness Hale and Lord Clark were willing to contemplate as legitimate. And that conclusion is, we say, not altered when one looks at the Travo and Article 32 of the, or rather looks at the Travo pursuant to Article 32 of the Treaty Convention. And Lord Sumption relied upon the Travo, paragraphs 34 to 38 of his judgment, EF 881 to 883, and we say his reliance on the Travo was flawed for three reasons. Firstly, as we say in our printed case at paragraph 77, even from an international perspective, recourse to the Travo, while not precluded, has to be approached with a degree of caution. Secondly, as a matter of domestic authority, recourse to the Travo is only permissible where they, I should say, clearly and indisputably point to a definite legislative intention. And this is the point I made earlier, and which I gave the reference to Lord Stevens for earlier. That was the view expressed by Lord Wilberforce in Fothergill at 278b of the report, EF page 2026 at page 2053. And his speech was expressly agreed with by both Lord Scarman and Lord Roskill. Lord Scarman at EF page 2065, Lord Roskill at EF page 2077. And thirdly, applying that test to this case, the Travo here simply do not indisputably point to a definite legislative intention of the kind contended for by Mr. Basfar, the respondent, and against the destination which we say every other aspect of the Treaty Convention exercise points to. And in this regard, we set out our position at paragraphs 80 to 84 of our printed case, and we make the 5 points that are set out there. Firstly, the Travo simply, and as I emphasised earlier, the Travo simply do not address the key issue in this case as identified by Lord Wilson, namely whether engagement by a diplomat in human trafficking constitutes engagement in commercial activity. And so the threshold test set by Lord Wilberforce is simply not met on that basis alone. Secondly, even redefining the issue, as the respondent would seek to do, to ask whether any employment of any domestic servant constitutes commercial activity, so as to be within the exception. As I've already submitted, I don't need to go that far, but there is certainly nothing equivalent in the Travo to what, for example, Lord Scarman in Fothergill saw as material of particular weight, namely an agreed minute as to a meaning in a treaty. Even if, as he is, Mr. Basfar is able to point to different observations by individual delegates consistent with that aspect of his case. There is instead at least one observation, certainly on one reading, unchallenged by the Special Rapporteur to the drafting process, asserting, as I submitted earlier, that there was already in train a trend showing that entry into the labour market implied acceptance of jurisdiction, and that this trend could either be encouraged by an express exception being included within the Diplomatic Relations Convention, or, as the delegate put it, matters could merely be allowed to take their course. It's the point we make in our printed case at 81, EF 352-3. And the best the respondent can do in response to that point, it's based upon an observation by the Yugoslav delegate, is to say that the Special Rapporteur rejected the delegate's proposal, and that the delegate later implicitly recognised, this is how it's put in the respondent's printed case at 47.1, implicitly recognised that the exception was not wide enough to embrace employment relationships. Well, that's a long way from the Fothergill test, we would say. Thirdly, and again this much is of course common ground, the delegates were of course leaving the term commercial activity undefined, and doing so against the background of the emergence of restrictive immunity that I've already referred to. Fourthly, again, a point I've made in different contexts, to the extent, and there is material to this effect, to the extent that the Travo saw commercial activity as something wholly inconsistent with the position of a diplomatic agent, or repugnant, or contrary to the dignity of the diplomat's position, then again, of course, involvement in human trafficking would obviously meet that test. And fifthly, there is no sufficient basis, we say, for concluding that the Travo show that the activities covered by Article 31(1)(c) and Article 42 were intended to be precisely the same. I acknowledge there are many references which show an overlap, but they don't go as far as to show that the concepts covered were intended to be precisely the same. And indeed, even one of the commentators relied upon by the respondent, Professor Denzer, has acknowledged that the provisions do not dovetail. That's EF page 340 and EF page 1451. My Lords, my Lady, for all those reasons, we submit that a proper analysis of the Vienna Convention and the law of treaties approach leads to a conclusion in Miss Wong's favour, and that the time has come to endorse what Lord Wilson contemplated as possible, as indeed correct. Unless there are any further matters I can attempt to assist on, that's how I put Miss Wong's appeal.
No, I think you've been of sufficient assistance already, Mr. Arty. Thank you very much.
Thank you, my Lord.
Mr. Sethi.
Yes, my Lord, my Lady.
Could I just say in passing that the extension of time which we acceded to on Mr. Sethi's application last week has all been given to him, both because he asked for it and because he's addressing a point solely raised by the second intervener.
Thank you, my Lord. Yes, I saw the note on that. Thank you.
Yes, Mr. Sethi.
Thank you, my Lord. My Lords, my Lady, in addressing my learned friend's submissions and in response, I propose to address your Lordships and your Ladyship on the following matters in the following order. And I suggest that this is the appropriate starting point, midpoint, and end point of the analysis and the logical manner of proceeding in this appeal. To start with trafficking is not the appropriate starting point. and I think my lady friend at one point himself indicated that there is a great importance here to analyse and begin the analysis from the correct point on the issues. My Lords, my Lady, I suggest that the appropriate structure of analysis is really as follows. Firstly, that I address this Court on the Vienna Convention on Diplomatic Relations and the concept of diplomatic immunity. That I jump very quickly, given the submissions you've already heard, to the fundamental rationale behind diplomatic immunity and how that differs materially in substance and scope and strength to that immunity which subsists for states. I then want to move on to look at the scheme of the Vienna Convention, because, of course, one needs to look at the entire, any given provision in context, looking at the entire treaty. Then to move on, perhaps tomorrow morning, given the time, to responding to the very specific arguments that my learned friend raises in his written case on behalf of Miss Wong. Issues such as the link between Articles 31(1)(c) and 42, if it indeed exists, and I say it very clearly does, the Portuguese Supreme Court authority of Fonseca, and matters of that kind which he prays heavily in aid of. I'll then move on tomorrow morning to deal also with the correct approach to interpretation of a treaty such as the Vienna Convention in accordance with the Treaty Convention. And what I say is the correct interpretation when applying those provisions to the construction of a treaty article such as the one under consideration, by reference to matters of ordinary meaning, to context, to object and purpose. And then, because it's permitted by the treaty interpretation provisions, to look to the preparatory work to see whether that confirms my invitation to your lordships and ladyship to agree with the construction I pose to 31(1)(c) by reference to the preparatory work, in other words, at that stage in the analysis. I'll then propose tomorrow to move on to, thereafter, our interpretation of Article 31(1)(c) and how that is supported by whatever domestic jurisprudence there currently is, that is in play here, Propend and Rees up to the Supreme Court, insofar as there are obiter but persuasive dicta. All the international applicable jurisprudence, particularly that of the United States of America, to look at all of the leading academic commentary, which, in my respectful submission, entirely supports Mr. Basfar's position on this. And then I'll move on to explaining tomorrow why Ms. Wong's interpretation of Article 31(1)(c) is wrong, given the background building blocks to that position of my argument that I shall address your lordships and ladyship on. In doing so, we'll of course then be applying the law to the assumed pleaded facts in this case. And I'd want to specifically address your lordships and ladyship on the limits of the assumed pleaded facts here. And the fact that we are not in the business of trying to run any new points on appeal, because these points are effectively built into the definition and the application of the definition of Article 3A of the Palermo Protocol on trafficking. I also deal with how we say the assumed pleaded facts in this appeal do not meet that international definition of trafficking, and how the actions in the Employment Tribunal do not relate to commercial activity. I'll finish with that first section before I get the extra hour in responding specifically to Calayan's international and constitutional law arguments, specifically, because they are distinct from the arguments run by Ms. Wong. and I hopefully can deal with those relatively briefly. And then to use the extra hour given to me to deal with the fresh additional human rights arguments being advanced by the UN Special Rapporteur, based primarily on Articles 6 and 4 of the Human Rights Convention. So that is the roadmap, my lords, my lady, that I propose to follow. I'm hoping within that you will see that I will not leave an argument unaddressed. So looking firstly then to the VCDR and diplomatic immunity at its fundamentals. Now we appreciate that legal immunity for diplomatic agents is an ancient, it is a fundamental, customary international law principle. Lord Sumption in Rees accepted as much. This so much is uncontroversial. At page, and all page references I shall give shall be to the EF digital page number. At page 868, at paragraph 5. Where he said on the page at D, under the heading of the legal framework, his introductory words, the legal immunity of diplomatic agents is one of the oldest principles of customary international law. And then he goes on, as one can read there, to deal with it going back to ancient and Roman times. I don't propose to read that paragraph, but it is there. The next point to make here at the outset is the very first recital of the convention. That's at page 587, which reads, recalling that peoples of all nations from ancient times have recognized the status of diplomatic agents. Now, as we've set out in our written case at paragraph 3, Article 31(1)(c) of the VCDR is one of what we describe as only 3 carefully and narrowly constructed exceptions to this ancient and fundamental customary international law principle of legal immunity for diplomatic agents contained in the 1961 Convention. That principle was also described by Lord Sumption, the principle of the exception, at paragraph 7 in the Supreme Court, as a fundamental principle of national and international law. And I suppose the point one needs to make at the outset is to suggest that the immunities and the immunity in 31(1)(c) is not one of the core aspects of the Vienna Convention is wrong. In a recent case of local authority and the Attorney General, Mr. Justice Mostyn referred to this 31(1)(c) exception as sacred and inviolable. That's at page 1625, paragraph 26. And at paragraph 38, Roman numeral 4, Mr. Justice Mostyn in that case also referred, and this is digital page 1628, to it being one of the most important tenets of civilized and peaceable relations between nation states. At the beginning of my submissions, what I'm going to be seeking to do is lay a series of propositions of law, which I'm hoping will be uncontroversial, but they will be illuminative of the ultimate answers one needs to look for on this appeal. Now, in my submission, the VCDR comprehensively codifies the law of diplomatic relations, reflecting centuries of state practice. And as we set out at paragraph 10 of our written case, a leading and undisputed leader in the academic field on the subject, Professor Eileen Denzer, wrote of the VCDR, and this is page 1407, quote, that these rules protecting the sanctity of ambassadors and enabling them to carry out their functions are the oldest established and the most fundamental of international law. The Convention is a cornerstone of the modern international legal order. It guarantees the efficacy and security of the machinery through which states conduct diplomacy, and without this machinery, states cannot construct law, whether by custom or by agreement on matters of substance. Indeed, the Foreign and Commonwealth Development Office, intervening in the recent case of London Borough of Barnet and Attorney General in 2021, gave evidence to the court of the vital role the VCDR plays in the conduct of international affairs at paragraph 49 of that decision. We know that 193 states in the world, almost all of them, very nearly almost all of them, have ratified the VCDR without, importantly, without declarations or reservations in respect of the provisions relevant to this appeal. And it has received, according to Professor Denzer, quote, a remarkably high degree of observance worldwide. Page 1407. And this point is made in our written case at paragraphs 11 and 15. The interpretation and application of Article 31(1)(c) of the VCDR by this court will inevitably and importantly therefore be a matter of significant interest and concern to nearly the entire international community. One cannot overestimate that or overemphasize that important factor. Articles, in terms of looking to the structure of diplomatic immunities, they are principally contained in Articles 22 to 40 of the Convention. They appear at pages 592 onwards. And we deal with this in our written case at paragraph 12. There are 5 principal areas here. First, that diplomats are exempt from all dues and taxes subject to limited exceptions, Article 34, page 595. The person of a diplomat is inviolable and shall not be liable to any arrest or detention, Article 29, page 594. Thirdly, no measures of execution may be taken, save in cases coming under Article 31(1)(a) to c, and provided that they can be taken without infringing the inviolability of his person or his residence. That's Article 31(3), page 594. The diplomat is not obliged to give evidence, 31(2), page 594. And fifthly, he has or she has absolute immunity from criminal jurisdiction, and also enjoys immunity from the civil and administrative jurisdictions of receiving states, subject to 3 narrowly prescribed exceptions in Article 31(1), page 594. And one point I should say at the very outset, because it's almost the elephant in the room, as it were, and that is that when we go on to look tomorrow at the Palermo Protocol, and we go to look at the obligation on states to implement it and punish perpetrators of trafficking and to compensate victims of trafficking, we are looking at a crime. It is the crime, it's a criminal offence, trafficking. And the UK government has passed the Modern Slavery Act, and trafficking is a defined criminal offence in Section 2(1) of the Modern Slavery Act 2015, and it's there because of the UK's obligations under Palermo and the Anti-Trafficking Convention to ensure that there is a punishment of perpetrators and that it is dealt with as a crime, which it is. But we all can see that the starting point, which should never be forgotten here, is that all diplomats have absolute immunity from the crime of human trafficking. And my learned friend doesn't seek to argue otherwise, but it's a fact which really must not be forgotten. That Ms. Wong's case appears to suggest that despite diplomats having absolute immunity from the crime of human trafficking, despite Palermo and the Anti-Trafficking Convention and all the other international treaties on anti-slavery, that there is still thereafter some obligation to compensate through an employment tribunal claim for, say, wages, to somehow make a declaration of human trafficking, the crime of human trafficking, because it's nothing less than a crime, and to provide compensation for that wrong. And of course, that is where we say the tribunal does not have the statutory powers to deal with that.
Well, the tribunal clearly has a statutory power to decide whether it's got jurisdiction.
Precisely.
And that will involve a determination as to whether there has or hasn't been trafficking on the appellant's case. And it doesn't go on then, thereafter, to make an order based upon trafficking. It bases it upon employment rights.
Yes. And entirely agree with that, my lord.
The fact that you can't prosecute for a crime, why does that prevent you from obtaining a civil remedy? What's the relevance of that?
The relevance of that within the context of the employment tribunal, and I shall come on to this in detail tomorrow, but just to answer the point head on, is that the tribunal is a creature of statute. It is limited to making declarations of breaches of statutory employment rights and providing compensation for breaches of those particular rights. Those statutory causes of action do not involve the employment tribunal, in this case, in an inquiry as to trafficking or the harm done by trafficking. It is, in a wages claim, looking simply to see whether there has been improper, unauthorised deduction from the wages properly due to the employee contractually. That is a different point to the point, my lord, you have rightly, and I entirely agree with, raised, which is that for the purposes of a preliminary hearing on jurisdiction, where the matter of trafficking is raised in order to defeat the plea of immunity, then of course the tribunal has power to determine the scope of its jurisdiction and will look into whether the trafficking definition is met. I accept that. But not when it comes to determining the statutory causes of action which it is apprised of doing, because its powers are strictly limited to what it can do within those causes of action. And the Article 15 point, which I'll come on to tomorrow in detail, but the Article 15 point, to meet that head on, the obligation to provide compensation for the criminal wrong of trafficking, it has been provided for in the Modern Slavery Act by way of various compensatory orders. But of course, we know that is a crime, and there's absolute immunity to that. So, if I might turn to look to the rationale. I'm sorry, Molly, did you wish to raise anything further? Great. Looking to the rationale for diplomatic immunity, and I do say that when one approaches this matter with fundamental principles first, the building blocks of what this is really about, the context in which we are looking at matters of trafficking, this is the order in which to do it. Otherwise, one ends up coming at the issue and not understanding the underlying purpose, the object behind the 31(1)(c) provision. And so we must look at trafficking at a slightly later stage in the analysis. So, the rationale. What is the legitimate aim behind diplomatic immunity? What is it for? What does it cover? What overlap does it have with the doctrine of state immunity? Does it serve distinctly different purposes? These are the questions which need to be grappled with head on. And despite Lord Wilson in Reyes not readily seeing the distinctions, there are readily ascertainable distinctions in the authorities, and it's not clear that Lord Wilson was necessarily taken to those. Now, both state immunity and diplomatic immunity exist to promote good relations between states. Undeniable. But diplomatic immunity, in essence, has a further purpose, and that is to prevent the functioning of the diplomatic mission from being impeded, to protect the diplomatic agent's freedom in the receiving state to exercise his official functions. Ne impediat legatio. And that's why it is said that diplomats face a special and corporeal vulnerability, unlike states and unlike consular officials. And if one needed authority for these propositions, perhaps a good starting point would be the decision of the then President of the Employment Appeal Tribunal, Mr. Justice Langstaff, in the Rees litigation. If one goes to page 732, paragraphs 33 and 34, where Mr. Justice Langstaff held as follows. The purpose of conferring diplomatic immunity is not identical to that of state immunity, though closely related to it. In Aldona S. and Royaume, Uni, a decision of the Poland Supreme Court, a typist dismissed from the service of a British Foreign Office publication without being paid arrears of salary due to her claim in Poland against the United Kingdom. Her claim was rejected on the basis of state immunity by the District Court of Appeal. It came before the Supreme Court. It too dismissed the claim. It observed as follows. The legal basis of immunity from jurisdiction of a state is different from the immunity of diplomatic agents. Immunity of foreign representatives is meant to protect their freedom in exercising their functions, ne impediat legatio. Whereas the basis of the immunity from jurisdiction of foreign states is the democratic principle of their equality, irrespective of their size and power, which, in consequence, excludes jurisdiction of one state over another, par in parem non habet judicium, unless there has been voluntary submission to such jurisdiction, either by a definite document or by a conclusive action. On examining questions concerning immunity from jurisdiction of foreign states, one has to base oneself directly on general principles universally adopted in international relations. The most essential of these principles is the principle of reciprocity among states, which results from the fundamental principle of their equality. This principle must govern diplomatic immunity as well, notwithstanding its different aspect. The principle of reciprocity is based on recognition or non-recognition of the immunity from jurisdiction by one state of another in the same measure as the latter recognizes or refuses to recognize immunity from jurisdiction of other states. Hazel Fox, QC, in her seminal text at the Law of State Immunity, not only cites Aldona S., but notes that the German Federal Constitutional Court was of the same view in the leading case, claim against Empire of Iran. There, the German Federal Constitutional Court, considering the exceptions to immunity in Article 31 of the Vienna Convention, held, at page 75, quote, that article governs the personal immunity of diplomats. The extent of this immunity differs from that of state immunity. Generally, it extends further. In principle, therefore, the extent of state immunity cannot be determined from that of diplomatic immunity. And in that case, I similarly submitted that the extent of diplomatic immunity, it didn't work the other way around either, could not be determined from that of state immunity, particularly since the leading case regarded the former as extending further than state immunity. And then at paragraph 34, Mr. Justice Langstaff observed that the need to protect the special vulnerability of a diplomatic agent when present in the territory of a receiving state for the purpose of representing the sending state is a major justification for diplomatic immunity, which does not apply in the case of state immunity. The latter being based on the concept of equality between sovereign states, such that the law of one cannot hold sway over the other in the absence of agreement. bringing a claim against the state does not necessarily prevent or hinder the conduct of the affairs of the sending state, whereas making a serving diplomat personally subject to criminal or civil proceedings, however justified they may be in the domestic law of the receiving state, is always liable to hinder his performance of his official functions. He is entitled to inviolability of his person, and reference to Eileen Denzer's diplomatic law shows how widely this extends. A legate of a foreign embassy may not be hindered in performance of his functions as such. That was in the Rees litigation itself. Those observations were not overridden subsequently on appeal to the Court of Appeal or the Supreme Court. And in the Supreme Court, Lord Sumption referred to the matter at paragraph 28. This is at page 879. Paragraph 28, Lord Sumption held, however, the analogy should not be pressed too far. And this is the analogy with state immunity. In some significant respects, the immunities of diplomatic agents are wider than those of the state. This is because their purpose is to remove from the jurisdiction of the receiving state persons who are within its territory and under its physical power. Human agents have a corporeal vulnerability not shared by the incorporeal state which sent them. Refers to Section 16 of the State Immunity Act 1978, which defines the ambit of state immunity in the United Kingdom, and Article 3 of the UN Convention on the Jurisdictional Immunities of States. Both provide that the rules relating to state immunity are not to affect diplomatic immunity. So we have both at domestic and international level an express statement in those provisions that the rules relating to state immunity do not affect diplomatic immunity. That's important. These provisions are necessary because, as Professor Denzer points out, in diplomatic law, quote, as international rules on state immunity have developed on more restrictive lines, there has always been a saving for the rules of diplomatic and consular law, and an increasing understanding that although these sets of rules overlap, they serve different purposes and cannot in any sense be unified. Cannot in any sense be unified. So one needs to really begin with an understanding of what is the legitimate aim sought to be pursued by the concept of diplomatic immunity, how that differs from state immunity, when particularly later in the course of the analysis one is looking at any of the numerous authorities that you've been taken to on state immunity to see how that impacts upon the object and purpose of the Vienna Convention on Diplomatic Relations. Another authority worth citing is London Barnett and the Attorney General. It's page 1676. If I may take your Lordships and Ladyship directly to paragraph 50 for present purposes. Where it was held that, just as importantly, it also governs the operations of UK diplomatic missions abroad, as well as the conduct of the UK diplomatic staff.
What's this a quote from?
I better read from 49, where, on page 1676, my Lord, where the judge speaks of the operation and importance of the VCDR, was elaborated in the witness statement of Ms. Macmillan, MVO Deputy Director of the Protocol Directorate and Assistant Marshal of the Diplomatic Corps of what became in June 2020 the Foreign Commonwealth and Development Office, FCDO. In her long career in the diplomatic service, she had come to appreciate the vital role that the VCDR plays on a day-to-day basis in facilitating the peaceful and enduring conduct of international affairs. It safeguarded the efficacy and security of the apparatus through which states interact with one another. It provided the structure for the daily interactions of the diplomatic missions and international organisations unit, which she oversees with foreign diplomatic missions and their staffs. It's referring to the evidence that she gave on the matter. And just as importantly, it said, quoting from her, it also governs the operations of the UK diplomatic missions abroad, as well as the conduct of the UK diplomatic staff who served those missions throughout the posting, from appointment and accreditation to the termination of the diplomatic functions. The immunities and privileges that the VCDR confers allow diplomatic staff to carry out their essential work without fear of reprisal, no matter how unpopular their mission and no matter how difficult the conditions in the receiving state. From the FCDO's perspective, this protection is one of the valuable elements of the VCDR in practice, and one that is rigorously upheld by the UK even in times of crisis. And it goes on to deal with the important point about reciprocity in that context. You also have...
Follow the point. I'm sorry, Mr. Sethi. Is there a fear that there will be trumped-up charges that wouldn't arise in any event under the exception, commercial exception?
There is always the fear of trumped-up charges.
Yes,
we may have an appreciation that perhaps that is highly unlikely in our jurisdiction, but this is a worldwide treaty, and one has to assume the realities of the legal systems in other jurisdictions where that is a very real risk.
Diplomatic relations seem to have survived that.
Indeed.
In other jurisdictions. And I just don't understand why it is that one should consider that there is an increased risk, as it were, if the appellant's definition is correct. And how Portugal got away with it, because Portugal allows claims for employment.
Yes, I can deal very specifically with Portugal. I've got three very distinct reasons why that should not be followed. Would your lordship like to know?
Are you seriously contending that there is an increased risk of trumped-up charges if the appellant's construction is correct?
The authorities do point to the risk that if an immunity of this kind is whittled away by one straight party, that will be met with a reciprocal retaliatory effect in other contracting states. So there are genuine concerns in the evidence that's been given by the Foreign Office and others to various of the authorities that I shall take your lordship's and ladyship to, where the evidence of the government is that is a real risk, yes. Now, my lords, my lady, I deal with this in
Sorry to interrupt. I assume nobody suggested the government should intervene either in Ray's or in this case to tell us what they think about this particular point.
The Foreign and Commonwealth Office did intervene in Ray's, of course, but not in this litigation.
Did they give... sorry, I missed it then. Did they give a view about the likely impact if Mr. Rotty's interpretation were correct?
Yes, we have the Foreign and Commonwealth Office's submissions in Rees to the Supreme Court in the bundle before you. I'm just going to get the page reference.
Right, thank you.
5540. No? What is it?
5618.
There are two sets of submissions from the government. 5540 were the Secretary of State's written submissions to, in fact, not just written submissions, but skeleton argument to the Court of Appeal, 5540, and at 5618, we have these submissions to the Supreme Court in Rees. In a recent response to a petition brought by domestic workers against US diplomats, the response of the United States is in the bundle at page 5250. So you have the position of the UK government in the Court of Appeal in Rees and in the Supreme Court in Rees, and now I'm just going to take you to that of the US government on a recent petition by domestic workers employed by diplomats. And if I can take your lordships and ladyship to page 5279. We have the US State Department observing this critical distinction between state and diplomatic immunity, serving different purposes. Top of page 5279. As explained in section 3A, diplomatic immunity is a doctrine whose purpose is to ensure the ability of diplomatic agents to carry out their duties in a foreign, sometimes hostile environment. In contrast, state immunity derives from the fundamental equality of states in the international system. The possibility of being subject to judicial proceedings would pose a much greater threat to the ability of diplomatic agents to carry out their functions than to the state's ability to pursue its affairs internationally. Accordingly, immunity for sitting diplomats is greater than the immunity accorded to states. I hope and trust, my lords, my lady, that I have fairly made the point that the starting analysis of diplomatic immunity is to truly understand its rationale, the legitimacy of the aim that it seeks to pursue, and its distinction with state immunity. And we've made these points in our written case at paragraphs 14 and 18, and in our response to the UN submissions at paragraphs 13 and 19 for completeness. So, understanding the rationale is fundamental, we say, to construing the scope of the narrow exceptions to diplomatic immunity in 31(1)(a) to C. Immunity from criminal and civil jurisdiction, subject to carefully circumscribed exceptions, is a core aspect of the VCDR and is required by the principle of ne impediat legatio. Exposure to criminal and civil proceedings is always, as those authorities indicate, liable to impede the diplomatic agent's functions. There are various other authorities for that particular proposition. Lord Sumption addressed this specifically at paragraph 17, page 874. Where at paragraph 17 he observed that Articles 31 to 40 of the Convention represent an elaborate scheme which must be examined as a whole. Fundamental to its operation is the distinction which runs through the whole instrument between those immunities which are limited to acts performed in the course of a protected person's functions as a member or employee of the mission, and those which are not. The distinction is fundamental because what an agent of a diplomatic mission does in the course of his official functions is done on behalf of the sending state. It is an act of the sending state, even though it may give rise to personal liability on the part of the individual agent. In such a case, the individual agent is entitled to both diplomatic and state immunity, and the two concepts are practically indistinguishable for that purpose where there's overlap, of course, and refers to the authority of Jones. By comparison, the acts which an agent of a diplomatic mission does in a personal or non-official capacity are not acts of the state which employs him. They are acts in respect of which any immunity conferred on him can be justified only on the practical ground that his exposure to civil or criminal proceedings in the receiving state, irrespective of the justice of the underlying allegation, is liable to impede the functions of the mission to which he is attached. The degree of impediment may vary from state to state and from case to case, but the potential problem for the conduct of international relations has been recognised from the earliest days of diplomatic intercourse, and in the United Kingdom ever since the arrest of the Russian ambassador for debt as he returned from an audience with Queen Anne, which led to the passing of the Diplomatic Privileges Act 1708. So the point there is that a diplomat exercising official functions is covered by diplomatic and state immunity. A diplomatic agent not exercising, acting outside his official functions may still be immune, but a diplomat carrying out the commercial activity narrow exception does not have immunity. The point I'm simply trying to make very clearly at the outset is that this is not a black and white issue between a state act or an official act versus only a commercial act, that it can only fall in one of the two camps. There is recognised here, expressly within the Convention structure and purpose and object, a middle ground. It is a middle ground of something which is not an official act, but does also not fall within the limited narrow exceptions. That is a point that my learned friend has studiously avoided addressing.
And insofar as there might be conduct which is not covered by state immunity, but where the claim is based on the actual conduct of the diplomat, what he actually did as the human being representing the state, is called into question, then I suppose the fact that he's not obliged to give evidence in those circumstances protects him from getting involved in a claim against the state based on his behaviour, if I can put it generally like that.
If it is a claim against the state, but the complaint is one of his non-official acts, then there would be a defence that it's not an act of the state, it's not a sovereign act. And both the state and the diplomat would have an interest in such litigation. So if it's brought against the state there, one would see that the state would want to dispute that it's a sovereign act that's being complained about. If it's a complaint brought against the individual diplomat, he or she would have a legitimate interest in, even though he doesn't have to appear or respond, he clearly has the risk of a public declaration being made against him and his reputation being called into question, and matters of state may be involved in the allegations, even if it's not said to be sovereign acts that are the background to the cause of action, my lady. Does that answer the question? I'm grateful. And one also sees this from the President of the Employment Appeal Tribunal when he dealt with the race case. And if one goes back to page 733, paragraph 34, and I think I may have dealt with that. Yes, I took you to 34 already, but that deals with this point. And in Barnett, at page 1677, paragraph 55, the following point is made, that Miss Macmillan highlighted two aspects of the potential risk to safety and security adumbrated by Mr. Justice Mostyn. The first is the reality that many of the 192 state parties to the VCDR are not equipped with fair, effective and independent judicial systems and law enforcement agencies. My Lord, that's a point that I was making a moment ago. Our diplomatic staff and their families could face politically motivated charges and possibly arrest and detention, which would both put their safety and security at risk, but also prevent them from carrying out their vital work on behalf of the UK. This would be a particular risk if the mission or instructions were politically unpopular in the relevant receiving state, or if the conditions in the state deteriorated. These sorts of risks are precisely what the rules enshrined in the VCDR were intended to avoid. Secondly, an exception to inviolability or immunity made unilaterally on one basis, for example, child welfare, could easily be extended to encompass other factual situations, for example, public security, public morality or blasphemy, and other provisions of the VCDR, not just by the courts and legislature in the UK, but also by those of other states. And then it goes on to deal with further consequences. And my lords, my lady, we deal with this point in our written case at paragraphs 20 to 21 and 45, subparagraph 3. But the point that we're at the moment in the analysis, it can be summed up by the observation of Professor Denzer, which was cited by Lord Sumption. Lord Sumption took the quote he did from page 1407 in Professor Denzer's leading text, when she said, and it is a passage, forgive me, it's a passage I did cite earlier, but when she said, importantly, as international rules on state immunity have developed on more restrictive lines, there has always been a saving for the rules on diplomatic and consular law and an increasing understanding that although these sets of rules overlap, they serve different purposes and cannot in any sense be unified. And that's the importance of that passage in the current context. So diplomatic immunity is wider than state immunity, and it is stronger in its ability to resist any erosion than state immunity. The point about strength and width of diplomatic immunity was made by Lord Sumption at paragraph 28, but is also made by Mr. Justice Langstaff at paragraph 40 in the EAT at page 734. It's a passage I hadn't taken your lordships and ladyship to. It's page 734, paragraph 40. If I have correctly identified the underlying principle, that of placing no hindrance in the way of the serving diplomat being free to perform his tasks, it explains why diplomatic immunity is authoritatively recognised to be wider than state immunity in its scope. The principle underlying it is different, and he makes the observation that the judge in that case did not clearly begin her assessment by starting from these principles. She did not sufficiently nor precisely identify the legitimate aim against the achievement of which the interference was to be balanced. So when one is looking at the immunity and the narrow exceptions to the immunity and construing those in an international multilateral treaty provision, it is important to understand firstly what the purpose of the provision of diplomatic immunity is. And we've dealt with that at paragraph 26 of the written case. However, my lords, my lady, the ne impediat legatio does not entail immunity in respect of distinct business activities undertaken by the diplomat. We say for profit, which are wholly independent of his official functions. And the authorities for those propositions are quite clearly set out by Lord Sumption at paragraph 21.5, page 876. Where he held that there are obvious reasons why an exception such as that in Article 31(1)(c) should have been limited to someone participating in a professional or commercial business. It is inherent in the concept of jurisdictional immunity, that it will shelter a serving diplomat and, in some circumstances, a former diplomat against legal proceedings in the receiving state. It is not inherent in that concept that the immunity will enable him to exercise a distinct business activity in competition with others, while sheltering him from the modes of enforcing the corresponding liabilities which are an ordinary incident of such an activity. Lord
Sumption's pointing, I think, isn't he, that the rationale for the commercial activity exception being the need to ensure that those who are engaging in commercial activity and therefore entering into relationships with counterparties should be exposed to proper legal redress if they act in breach of those relationships. Or at any rate, they should be engaging in business activity on a level playing field so far as being liable for their conduct to their counterparties, just as their counterparties will be to them.
Yes, that is what he says.
That's what Lord Thompson's pointing at.
That's what Lord Thompson is pointing at.
I think he's saying it's obvious. Is there any other authority which bears on the rationale for the exception?
If one goes to Lord Dyson, the Master of the Rolls view in the Court of Appeal in Rees, this is page 833. Paragraph 16. Where the Master of the Rolls observes that this provision is illustrative of the principle which underlies diplomatic immunity, and here he's referring to Article 34, the diplomatic agent being exempt from all dues and taxes, personal or real, national, regional or municipal, except dues and taxes on private income having its source in the receiving state, and capital taxes on investments made in commercial undertakings in the receiving state. So one sees the link. This provision, he says, is illustrative of the principle which underlies diplomatic immunity. If a diplomatic agent does what he is sent to the receiving state to do, then the activities which are incidental to his life as a diplomatic agent are covered by the immunity. Private income and capital receipts from private investments made by the diplomatic agent in the receiving state are not the fruits of activities which are incidental to the life of a diplomatic agent. They are extraneous to it. So there is similar, not identical dicta, but the point being that when you're in the receiving state as a diplomatic agent, engaging in business transactions which have nothing to do with your official functions and are not incidental to your official functions, which is the middle ground, then there is no purpose that is being served by the application of diplomatic immunity.
Well, that's about a different exception.
Yes, but
namely the Article 34 exception to immunity from tax liability.
But Lord Dyson is referring to Article 34 to assist in illustrating the principle which underlies diplomatic immunity generally within the Convention.
But I find that a very helpful statement of the rationale, because it explains that you want the protection to be not just your official acts, but ordinary incidents of life when you come to live in the country.
Yeah. Indeed.
So if you go and buy a bottle of milk, or the dry cleaning in the American case, and perhaps if you employ a domestic servant at home, that's an ordinary incident of life.
Well,
but human trafficking, arguably at least, is not an ordinary incident of life.
Arguably.
And so we're right outside the rationale for the exception.
Well, we will need to develop this point when we deal with human trafficking itself and the obligations under the Diplomatic Protocol. But of course, diplomats are unarguably immune from the crime of human trafficking. So, but yes,
but if we accept that it's commercial in the profit-making sense, then that's the umbrella it comes under. And it's just as extraneous to the ordinary incidents of life if you're profiting from trafficking in human beings as if you're trading in chocolate bars, to go back to an earlier example.
My Lord Legate is right that if that is the course of business, if this diplomat is engaging in a course of commercial human movement of humans and making monetary profit from moving human beings, then that is a business which is clearly within that example and wouldn't be covered by immunity. But
well, then we're coming down to quite a narrow point, really.
Well, I think we've progressed somewhat on this appeal before your lordships and ladyship, because my learned friend seems to have conceded, if I'm right, the point that he's not saying that the employment of a private servant is a commercial activity. It's the employment of a trafficked domestic servant, which is to put it in a short phrase, a commercial activity which he's seeking to narrow his appeal to.
But also,
yes.
When reading that passage initially, it could have been said, and I think I did make a note to that effect, that he is engaging in modern slavery is a private activity. And it is not endorsed by the sending state, and it is for profit. Those were the arguments I anticipated would be made in relation to that passage. So that passage potentially supports the appellant's case.
My Lord, well, not if we don't have material in this case that the diplomat is engaging in a course of commercial transactions for monetary profit.
He's gaining a profit by not paying somebody.
Well, therein lies a slightly distinct point, which I'll come on to and have to address tomorrow in some detail, and that is simply is this, I suppose, in a word, and that is whether by making a cost saving, one is turning a profit. Well, within the meaning of the Vienna Convention on Diplomatic Relations, and what that commercial activity exception was really aimed at, and the interrelationship between that and Article 42. But really, it's the meaning behind that then.
But it comes down, as I say, to a very narrow point, doesn't it? Because I think you probably accept, if you agree with Lord Sumption, that if somebody had paid your client to transport this person and treat her in allegedly appallingly, that would have been trafficking. Well, the question is whether it's different if instead of being paid he just makes, in effect, a financial gain through the exploitation of not paying somebody and treating them badly.
That would not be profit in my submission. We're very clear on this. You may be colloquially benefiting from a cost saving. There may be a benefit, there may be a gain of some description by not expending monies, but that is not the same as a fiscal profit
there's a difference between saving
commercial
cost and receiving a payment, is there?
Yes, precisely within the context of what the global community decided in Vienna. That was the basis upon which, and one gets confirmatory support for that when one looks at the preparatory work, which I shall come to in due course, which all point to that being the matter. So, for example, a diplomat could engage in academic lecturing in the receiving state, which would not be an official function, but would not be in the course of business, and matters of that kind. But there are a number of examples that are given in the by the negotiating parties in the travaux, which I think your lordships will require to look at. But we do have a disagreement between us that it would be the receipt of an income, the receipt of profit, not simply a cost saving, which perhaps is the issue between the parties on that point.
Certainly increase your available income by saving on costs.
Well, my lord, but that is not the...
Any business would be anxious to achieve exactly that objective.
Yes, but that would be very indirect in my submission.
But it's a difficult line, because one knows that traffickers in human beings often say, right, well, we put you to work, and what we deduct from your pay is what we had to pay for your flight or your food or your accommodation, and that is often why they don't get paid anything, because the trafficker purports to deduct from their salary expenses that he says he's incurred in transporting them and housing them and feeding them. So where would that lie?
When one, the answer to that, my lady, is that we have to look to the meaning of the words within the Vienna Convention and understand what the global consensus was in relation to the meaning of commercial activity, whether the global consensus was that that meant the same thing as it meant in Article 42, and what for personal profit means in Article 42. And if they're meant to cover the same ground, then it was a very narrow exception where somebody is turning a profit, making a positive physical gain in a monetary terms from business transactions, which in this case my learned friend will have to is seeking to say amount to the crime of trafficking. I've got quite distinct submissions in relation to whether the pleaded case amounts to trafficking. Of course, we've got a separate line of attack there, but the point about profit is very clear, both in the drafter's language in the preparatory work, both in Propend, which is the only English authority so far on the point, in all of the United States cases on 31(1)(c. They all deal with profit in the way in which I've submitted. There is not a single case which deals with profit other than simply the doubts expressed by Lord Wilson in raising the Supreme Court.
Well, thank you, Mr. Sethi. We'll have to see the nuts and bolts of that interesting submission tomorrow.
In the morning, my lord, yes.
We're going to resume it at the unusual starting time of 10 o'clock.
I'm very grateful.
To give you further time. But that's all we can manage today.